Okay. One other question that came up today as I was speaking with a client about a different type of case, and they were asking me about, should their assets be titled in a will or in a trust? And for me, as an estate planning attorney and an elder law attorney, I often want to review assets, and there's reasons why a trust-based plan may be very appropriate for someone. But sometimes we don't need to do a trust-based plan because, number one, they're very expensive because it requires a lot of work on the part of the planner. So that would be me, the drafter of the document. It requires a little bit more work. I have to do a lot more counseling with the client to make sure that the trust reflects back what it is that you want to happen when you become incapacitated and when you die, and even after you die. If we are talking about assets that are complicated, like estate taxable assets, so bigger assets, then of course, those kinds of trust-based plans are really important, along with if you have beneficiaries who maybe need special handling, like if they are not great with money, or if they have special needs themselves, or if they have addiction issues, or a variety of reasons, if they're in shaky marriages, or maybe reasons that we need to draft your trust instrument with a little more particularity, and it can take some time to do that drafting. Also, with trust-based planning, a lot of people will draft a trust and not fund the trust. And funding the trust means titling assets into the trust so that they would then be, administered by the terms of the trust. It's pretty complicated stuff, but generally, a trust-based plan is a set of instructions that comes into play when certain events happen. Normally, the two events that are important are your incapacity and then your death. And so, typically there'll be a set of instructions that tells us what to do when you become incapacitated, and then there would be a second set of instructions that might apply when you die. Now, there may be other sets of instructions that come into play, like when your children die or when a certain event happens. You can actually create trusts, like if someone becomes incapacitated, or a whole variety of reasons. Like, for example, one of the things that's unusual in our trust-based plans is that we have required prenuptial agreements. If like there's a couple and husband dies and the remaining spouse, let's say she wants to get, if it's a male and female couple, let's say that she wants to get remarried, there might be a requirement that for her to access husband's trust, she would need new husband to get a prenuptial agreement. So there's a whole bunch of things that we can do with trust-based planning that can be super complicated, but also very effective. So I always like to encourage people, what is it that you want to happen in your estate plan? And then we can help figure out if you should be in a trust-based plan or in a will-based plan, also depending on your beneficiaries and how much you want to control after you become incapacitated or die. Will-based planning is, also effective. It does mean that there would have to be a probate process. And will-based plans may be just fine for most people. But if you're in a second marriage, if you have property, like real property outside of your state, so like let's say you have property in Florida, but you also have property in Georgia. If you were going to do a will-based plan, that would mean you'd have to probate in Florida, and you'd also have to probate in Georgia. So for people like that, it might be better just to go ahead and do a trust-based plan. So, those are just some ideas of why we might put one in a will-based plan and in a trust-based plan. I hope that's helpful.